Judgment in the appeal, Telchadder and Wickland Holdings Limited.
Lord Wilson will explain the judgment of the court.
More than 85,000 people live permanently in mobile homes on what are called protected sites. The site owner grants the occupier a license to station his mobile home there. The Mobile Homes Act 1983 regulates the contractual arrangements between them. In particular, it limits the grounds on which the owner can terminate the license and so require the occupier to remove his mobile home and cease to live there. One provision, it's paragraph 4.2 of Chapter 2 of Part 1 of Schedule 1, enables the owner to do so if he satisfies a court, A, that the occupier has breached a term of the agreement and, after service of a notice to remedy the breach, has not complied with the notice within a reasonable time, and B, that it is reasonable for the agreement to be terminated. The wording of Part A of this provision causes difficulty. Mr. Telchadder owns a mobile home and occupies it on a protected site near Clacton, owned by Wickland Holdings. He is an eccentric man who at times has behaved antisocially towards other occupiers on the site, many of whom are elderly. In July 2006, Mr. Telchadder startled a female occupier by jumping out at her from behind a tree on the site while wearing camouflage, including netting over his head. He thereby breached a term of the agreement, not to act so as to annoy or disturb other occupiers, i.e., not to commit an act of antisocial behavior. The woman complained to Wickland, who, in August 2006, wrote to Mr. Telchadder saying that if he behaved like that again, it would apply to court for termination of his license to remain. This was a notice to remedy the breach within the meaning of Part A. Thereafter, nothing relevant happened until July 2009, i.e. for almost 3 years, when Mr. Telchadder committed a much more serious breach of the agreement not to commit acts of antisocial behavior. He told a male occupier that he was going to kill 2 female occupiers for having reported him to Wickland, and when the man told him to calm down, Mr. Telchadder threatened to shoot him dead too. The judge found, however, that he never intended to implement these threats. Wickland thereupon took proceedings to terminate Mr. Telchadder's license to remain on the site. It alleged that, in the light of that later breach, he had not complied with the notice to remedy which it had given in 2006. The judge upheld Wickland's claim, and the Court of Appeal dismissed his appeal. This court unanimously allows Mr. Telchadder's further appeal, but 3 of us reached that conclusion by one route and 2 of us by another. The first question is whether one can ever remedy a breach of a promise not to do something. Mr. Telchadder's breach in July 2006 was of a promise not to disturb other occupiers. The incident happened. It can't be reversed. So can it be remedied? All members of the court agree that some breaches of a promise not to do something can be remedied by the absence of a further breach, but that other breaches are so serious as to be irremediable. We also agree that the July 2006 breach was such that Mr. Telchadder could remedy it. We then go off at a tangent to consider whether the provision requires a site owner to serve a notice to remedy an irremediable breach. On that, unfortunately, we disagree. 3 of us consider that there is no need to serve a notice to remedy an irremediable breach, and that, while no doubt the owner will first explain to the occupier that it proposes to contend that his breach is irremediable, it can go straight to court and seek termination. Our 2 colleagues consider that Part A requires every breach to be the subject of a notice to remedy. But the central question is whether, in the words of Part A, Mr. Telchadder complied with the August 2006 notice within a reasonable time. One difficulty is that while it makes sense to say that the occupier must remedy a breach of a positive covenant by doing something within a reasonable time, it makes no sense to say that he must remedy a breach of a negative covenant by not doing something within a reasonable time. The other difficulty is to decide whether, in this context, a reasonable time means the entire future duration of the agreement or something less. 3 of us hold that it means something less, and that by not committing a further breach for almost 3 years, Mr. Telchadder complied with the notice within a reasonable time. Our 2 colleagues agree that his appeal should be allowed, but only on the basis that a causal or temporal link between the notice and the later breach is required by Part A, yet was absent in this case. A postscript is that had Wickland proceeded to court on the basis of the later breach, contending that it was irremediable, it might have been entitled to an order. Mr. Telchadder may be a lucky man.